this morning. We have two panels. The first panel will focus on the latest trends in global AI regulation, while the second panel will discuss the international cooperation. Both panels will be conducted in English only. And in our first panel, I'm very pleased to welcome four distinguished guests. You actually have seen, you've seen three of them, with the exception of Hiroki Habuka. He is a research professor at Kyoto University and the CEO of Smart Governance, Inc. And Hiroki, I would say, is the leading expert from Japan in this area. And he has represented Japanese government in various high-level discussions in international organizations. And we actually got to know each other when I visited NYU. And you gave us a wonderful talk at the Guarini colloquium. And so I'm so glad that you accepted our invitation to come here. And then we also have Thomas Streinz, a good friend of mine, and also the executive director of the Guarini Global Law and Tech, an adjunct professor of law at NYU. And on my right-hand side is Natalie Samuha. You have seen, Natalie is a rising star in this space. And also, I would also say you're a force of nature. You're so young and you were able to bring so many people together at Louvain to have the summer school. You're very entrepreneurial in that sense. Yeah. And we also have Michael Veale. I just learned that, first of all, Michael is an associate professor in digital rights and regulation at University College London. But I also just learned yesterday that Michael actually does not have a law degree. Is that right? But he has a degree. First degree is in political science, and the second degree, engineering. And no wonder you write such refreshing and interesting stuff, because this is an area which is highly interdisciplinary, and your technical background and your perspective from a different disciplines really breathe fresh air into the space, and that's why you're now a rising star in this area. So it's wonderful to have you. So now in this panel, we will talk about global AI regulation, which is very ambitious. We're going to cover, we talked a lot on China yesterday. So today we will focus on US, EU, and Japan, right? And potentially, if we have time, we can cover other jurisdictions. Now let's start with the United States. And I would like to pose this question to Natalie. Is the United States doing a lot in this space? I feel like, they make a big deal out of it when Biden administration introduced the executive order in October this year. And they said, and actually that executive order was released just 2 days before the Vice President Kamala Harris went to the UK summit. And I remember the White House put out a statement saying, look at our executive order. See what we have achieved. We stand at the forefront of regulating AI. We produce the most comprehensive regulation on AI. And I was kind of teasing that there was one, actually one official from the White House that I ran into when I was in New York. And I was teasing him, I was like, you guys don't need to brag about this, it kind of reflects that you're insecure about what you have done so far, because as we know, an executive order is an executive order. It's not like a law that is introduced by Congress, and it can only do that much. But we'll talk more about this. So Natalie, go.
Yeah, so the US did do some things, but it's certainly not a comprehensive regulation that is comparable to what the EU put forward. And there are many reasons for that. The US works in a different fashion. I mean, on the one hand, you would think the US could, in theory, do it quicker because they're not a supranational entity like the EU with 27 member states. But that's just not how things work there. So there is no binding AI-specific regulation in the US, and doesn't look like this is going to happen anytime soon. but it doesn't mean that there is nothing already happening. And actually yesterday, Marcelo Thompson gave already an overview of some of the main things that the US has been working on. So first of all, October 2022, we had the White House Office of Science and Technology policy that issued this blueprint for an AI Bill of Rights. As a European, if you read it, so I have European glasses when I look at these things, it looks very flimsy, right? It looks very aspirational, like we care about certain principles like safety, no bias, non-discrimination, privacy is important. And that's, of course, very true. And I think everyone agrees on that. But it wasn't very clear on how this would be implemented. That said, it did mark an important step because different than his predecessor, the Biden administration does seem to put AI, and not just AI development and investment, but also AI regulation in the very broad sense, so governing the technology, so not just imposing binding rules, much higher than, for instance, Trump did. So you could say that this blueprint was kind of a teaser for what would come, and then the executive order that you just mentioned goes a little bit further. So this executive order came out in October 2023, and indeed the timing was quite symbolic because it was just before the Bletchley meeting started in the UK to show the world that, you know, the US is there. And one of the things you see in the executive order that I found very remarkable is the emphasis on more international cooperation, and even language saying that the US wants to kind of take the lead in leading the dialogue on global AI regulation. So the US is very much putting itself on the forefront of global solutions for AI. Now, what does this executive order actually say? There is a lot of flimsiness still, ensuring that there is no discrimination, trying to create more privacy-preserving technologies. But there are a few more interesting things in there, and perhaps the most blatant one is the fact that the executive order asks developers of the most powerful AI systems to share their safety tests, so red teaming, etc., and other critical information with the US government. And this is done based on the Defense Production Act, which is a little bit of a strange animal. The Defense Production Act can, for instance, be used in times of war in order to make sure that companies, you know, provide information about their production capabilities so that in times of war, we can choose what to prioritize in terms of production. So it's a little bit unique to use it in that way, but of course, there's only so much an executive order can do. So this is a clever way, I would say, of enforcing some transparency. But it needs to be seen how this will be implemented, how it is defined, which systems, you know, are critical in order to share information. Another interesting thing about the executive order when we talk about generative AI is the fact that it focuses on developing standards in order to detect AI-generated content better. This is something we discussed yesterday. So authenticating official content is very important. If we don't know what is real or not, democracy is at risk. National security, as Marcelo said yesterday, is a word that comes to the forefront a lot in the executive order. And then, as I said, international cooperation. Now, there are a few other things that the US is doing. So just to give the complete picture, the government also tried to get some voluntary commitments from companies. And this might seem insignificant, but it's another way of trying to force companies to put forward their own ideas of what they can do. Again, from European Union glasses, this looks a little bit weak, but still, if you can get some commitments from companies, it's not bad if you can actually monitor them. So there were 15 companies that made some commitments in July this year. And just yesterday, a group of 28 more companies in the healthcare sector gave additional commitments. But these commitments, again, if you read them more closely, sure, it's about promoting safe AI, trustworthy AI. But as part of the commitments yesterday, for instance, I saw that it also says to vigorously develop AI solutions to optimize healthcare. So it goes both ways. In general, if we look at the US, just to wrap it up, the US relies much more on existing rules, right? There are consumer protection rules, there is competition legislation, data protection rules, copyright law, we talked about it yesterday, defamation laws. And so the idea is that a lot of these laws can already do fit the bill when it comes to regulating AI. There's reliance on private actions, right? So mostly in copyright, but also elsewhere. The State versus Loomis, for instance, is an example of an individual trying to challenge the Compass algorithm that was mentioned yesterday. And there are also public actions. So the FTC is taking a very prominent role based on consumer protection law and competition law. It's, for instance, investigating ChatGPT right now, OpenAI, based on consumer protection law. And this was following a complaint introduced by a civil society organization. So in general, the focus would be on large players, on trying to get the most out of existing legislation rather than adopting new AI-specific rules. I think that's how I would sum up what the US is doing now.
Oh, that's fantastic. Yeah, I would like to highlight two things. First is that you see a very interesting dynamic in the United States where the biggest player actually want to be regulated. They come to Congress, like I said, Altman testify at Congress, and they ask for regulation. They ask the government to impose a licensing regime in the US for foundation models. And there are some speculations like, look, I mean, they're doing this to increase entry barriers for smaller players. Because, they can, OpenAI, Microsoft and Anthropic, these are the big companies, deep-pocketed, that can afford this kind of regime, but the smaller startups would not be able to do that. I mean, kind of similar dynamic in China, where you can see, the licensing requirement actually make it more difficult for the Chinese startups. The other interesting dynamic I will also mention that is that in the US, even though the public enforcement seems to be weaker than the EU, but in the US, there's a very strong plaintiffs bar. It's a very litigious country, and especially in the IP area where you already see, more than 10 litigations are ongoing. Although, based on what I learned from Terry yesterday, it seems like these litigations are not going anywhere. So let me come to Thomas, right? I mean, I remember talking to people in Washington, D.C. These people, when they talk about introducing a comprehensive AI Act, they always bring up China. Right? I mean, Senator Chuck Schumer have done a lot in trying to, he did several big panel discussions with the top CEOs from the AI firms, and Donald seems to have done a lot, but people speculated it's very unlikely he can go anywhere because everybody will jump out and say, if we regulate, we will let China to get ahead of us. What do you think? How does this mentality affect the US approach to AI regulation?
Yeah, thanks a lot for the question and for having me. Again, I'm glad to be back and to weigh in on that question. So the phenomenon that Angela just described is indeed very present. China is a topic, as a trope in the political discourse in Washington, D.C. is difficult to overlook. And as someone who travels between Europe and the US, I sometimes feel like Europe is not talking enough about China, and maybe the US is sometimes talking too much about China. Because the underlying logic that lies behind this kind of argument that you can't regulate AI because otherwise someone else will win the race to AI has a really ridiculously under-complex understanding of what regulation is and how it works and how it relates to innovation and economic growth, or the kinds of values that we just heard about in the keynote. So that in reality, you might need regulation to get ahead towards the kind of AI society that you want to live in. And that argument has been made by many scholars, but it really struggles to penetrate into the political discourse in Washington, D.C. And it has been advanced by various actors in the AI industry as well. So you see the kind of phenomena that Angela just highlighted, that sometimes there's a call for regulation, regulate me, to create entry barriers, and sometimes it's a pushback against regulation. And in the pushback category, we quite often see the argument being made that you can't regulate AI or shouldn't regulate AI too much because otherwise other actors would get a step ahead, which doesn't make any sense, or doesn't make much sense, considering that China is indeed regulating AI, even though in a different way than the EU is.
Fascinating. Okay, let's come to the EU, because now EU has, always been seen as the most progressive and actually most aggressive player in regulations. My friend Anu Bruffa would describe EU as the global regulatory superpower. And that's why there is a Brussels effect, right? She coined the term Brussels effect, and it's also make her very famous, very successful. Look, I mean, my first impression of the EU AI Act, which has captured so much attention all over the world, is that, wow, this seems to be really strict. If firms need to satisfy all these very demanding requirements, I mean, how on earth can European companies compete with those in China and the United States? But hearing your talk, on the EU AI Act, I actually have the impression that it doesn't seem to be that strict, because at the end of the day, you don't have a licensing regime like in China. I mean, it's for the most part, you just need to do the self-assessment and then register what you have with the commission. I mean, is my understanding correct? I mean, tell us what exactly it is.
I would still say it's pretty strict if you compare it to most countries. So we don't have an ex-ante licensing regime. I think that's where the most important difference lies. So just for people who are not, who haven't read the AI Act, it's a very long document and we don't even have the final text yet. But basically you have some systems will be prohibited. That's very few. And in that sense, it's very far going. Some systems are considered as high risk. And these systems will be subject to a set of requirements, mandatory conformity assessment. And there it's true that almost all these high-risk systems, the compliance with these requirements happens by the companies themselves. So if I'm a company that falls under a high-risk system, I myself need to check whether I comply with these requirements. I need to document it, and I need to be able to provide the documentation upon request, but only ex post. So nobody will stop me from putting it on the market. I don't need a license for that. However, if somehow after I put my system on the market, it seems that I was not abiding by the strict set of requirements, and these requirements are quite descriptive. They're quite far going. So it will be costly to implement. In that sense, it's quite strict. If someone finds out I did not do it correctly, for instance, I did not make my documentation in a proper way, or I'm just not abiding by, for instance, sufficient testing against bias, non-compliance will result in significant fines, right? So again, we don't have the latest version of the text, but what I saw at the Parliament's fact sheet is that it might range from 35 million euros or 7% of the global turnover of a company. That would be the highest fine. 7% of your global turnover as a company is not nothing. So there is this incentive. There is, of course, the reputational damage that you can run if you don't abide by the regulation. So in that sense, it's far going. However, in order to make sure that Europe is not seen as only regulating and not allowing any innovation, it also tried to foresee some help for especially smaller companies, because I think you're very right in saying, Angela, that for larger companies, they can hire a set of lawyers to help them make the documentation, a pretty document, and they're good to go. Whereas for smaller companies, it's much more difficult. But there will be something called regulatory sandboxes, was introduced in the AI Act. And there are mechanisms that they are foreseeing, such as standardization, in order to help smaller companies to abide at smaller cost with these high-risk requirements.
I think you're too modest. You should tell the audience your involvement with the AI Act. Tell them.
Well,
you started at the Commission in 2018, right?
Yes.
Yes. Tell them about your story.
My story would be a bit long, but as I already mentioned yesterday, so the way the Commission went about it is it first set up a high-level expert group that came up with ethics guidelines for trustworthy AI,
Which is led by you?
Which I coordinated.
Okay.
Which I coordinated. But it's true that these guidelines were quite influential because we came up with 7 requirements that systems must meet in order to be trustworthy, the way we called it. And these 7 requirements were now translated into legislation in the AI Act. So basically what the Commission did, it took these guidelines. Some of these requirements are, for instance, ensuring human supervision, ensuring testing against bias, ensuring privacy is respected. And all of these things have now been translated into mandatory requirements, at least for high-risk systems. So in that sense, it gave the boost towards regulation.
Yeah.
But when it came to actually drafting the AI Act, I decided to go back into academia because I prefer them to do it.
But you were the mother of the AI Act, in a way. Yeah. Anyway, Thomas, would you like to chime in? Do you have anything to add?
Yeah.
By the way, Thomas is from Germany, so.
Yeah, so I'm also European, but maybe let's have a little good cop, bad cop routine on the AI Act in that regard. So you mentioned the Brussels effect, and the Brussels effect is, of course, very popular in Brussels. So the European Union is very proud of its ability to scale its rules around the world. And there's, of course, emulation going on. The AI Act has an influence on the global AI regulation debate, and companies will direct their compliance teams and maybe even the engineering teams towards AI Act compliance. But the Brussels effect is not a force or law of nature. It's highly contingent on the conditions under which AI gets developed by different actors in different places, and segmentation is an option. So you can develop an AI product, an AI system for the European market, and develop different AI systems for other markets. And in that way, it's also not an effect that applies to a law in total, so that the AI Act as such has a Brussels effect. One would need to look at the different requirements that the AI Act stipulates and figure out whether it makes sense for businesses to scale the requirement globally so that they can recoup the investment they make once to implement the AI Act to ensure compliance with the EU, or whether it makes more sense for them to develop a dedicated product for the European market and different products for other markets, or whether indeed it makes sense for them to not be present in the European market at all.
Excellent. Okay, we talk a lot about AI Act, but I think the attention is slightly biased in the sense that an AI service is subject to a wide variety of laws and regulations. You don't need, and I remember when I met Paul Nemeth, that's a very well-known and European Commission official, very senior. Actually, he's retiring this year. He's very actively involved. Can I call him the father of the GDPR or something? Yeah. He's very involved, deeply involved with the GDPR. And then when I spoke with him, and he was like, look, I mean, AI Act is the AI Act, but if you think about companies in the EU, the AI firms, the laws that they will be most subject to will be the GDPR and the Digital Service Act. I mean, these are the two major laws that he believes will govern the AI firm. So I want to bring up Michael. Can you give us the whole regulatory landscape of these laws that could potentially govern the AI industry?
Yeah. So there's a lot of different pieces of law in the European Union, and it's sort of broadly known as the Digital Single Market Package. Although it keeps changing, we can call it different things. We can focus on different areas. So I think the first thing to know about the AI Act is that it is quite a deregulatory regime in some ways, because it restricts what member states can do. EU law is about saying, okay, we are going to adopt one law in Europe, but that means that member states cannot act and regulate AI in this area. But that doesn't apply to other EU law, which can still be brought into the scope here. And so we can point to these different pieces of regulation and look at those. So let's start with one of them recently, the Digital Markets Act. This is a piece of regulation that addresses the concentration of power in the online platform economy and other kinds of economies like operating systems and cloud computing and similar that operate under similar logics. It defines not AI systems, but something called gatekeepers. These are powerful companies that control a few different powerful services, and they have a threshold condition to become into that category. Now, a part that hasn't really been widely commented on, maybe, I don't know if it has been written about at all yet, I need to look into it, is the fact that one of the core services in the Digital Markets Act is the virtual assistant. And virtual assistants, according to the definition, quite clearly encompass, in my view, something like ChatGPT and something which connects to other services and you can query, and the definition quite clearly brings those systems into play. So it doesn't encompass all AI, but it certainly encompasses, in my view, generative systems. And then you can look at what obligations are placed on gatekeepers that control particularly powerful virtual assistants. So they are not, for example, allowed to use data from those systems for advertising in other parts of their business without explicit consent from the user to make that combination. They have to open up their systems because it's expected they would use those virtual assistants to sell you a different product, to say, oh, well, you've been talking a lot about this and we also happen to sell this thing, so we'll do that. And while they are allowed to do that, they have to do it on roughly equal terms with other kinds of providers who could say, well, I want my products to also be inserted into your natural language conversation with what you thought was your friend, your digital friend, just saying, hey, so good to meet you again this morning. How are you doing? By the way, have you thought about buying this brand of toothpaste, friend? Okay, well, that's the future is, of course, going to be these systems funded by advertising, where they're going to just subtly try and make you purchase things. But the Digital Markets Act puts for the large providers a kind of more even playing field around that. There's also a range of provisions which I think, as we start to see the way that generative AI systems and their business models emerge, may make more sense. It's quite hard to anticipate right now. For example, what is an app or a piece of software in relation to a generative AI model? Would we say, okay, I want to install a certain module in my generative AI model so that it interfaces with other things that I use? We see that already with virtual assistants, sort of smart speakers like Alexa and Amazon Echo, which has sort of, Echo skills or Alexa skills, which are kind of an app store for these. But we're also seeing it with ChatGPT plugins. And so there are rules around enabling app stores, opening up these kind of services, which would necessitate third-party access to some of the innards of these systems to make that work. So there's also other parts of the Digital Markets Act which are interesting here, such as the rules that are placed on operating systems, which would oblige them to allow more than one generative AI system to access the hardware and the innards of that operating system. So you couldn't say, I have a Google phone, only Google Bard can run on this phone, and only Google Bard can make use of the special machine learning chip on the phone. There would have to be quite deep access to allow competitors into that space. The second and last piece of legislation I want to talk about, I don't want to talk about data protection. We talked about that a bit. We can do in questions or further discussion if we want, is the Digital Services Act. Now, I mentioned this yesterday. It's probably not the case that AI systems themselves will fall into the Digital Services Act directly, unless they start to be used themselves as a platform, like we are sort of uploading content into them and sharing content via them, which is certainly something that we can anticipate, but maybe a bit too speculative now. But we will see generative systems used within online platforms for recommendation, perhaps. If we start to not have this feed version of what we're looking at, we've been used to seeing a timeline or a feed within social media. But if it becomes more about natural language processing, explaining and altering what we're seeing, and a more discursive summary, as John was saying, the kind of possibility of summarizing these systems and summarizing other people's views into a different form is a feature of this technology. Well, then we can start to conceptualize these as recommender systems, which brings certain possibilities under the Digital Services Act for altering them and providing alternatives. There's also an advertising database in the Digital Services Act, which might provide transparency on how advertising is being used within generative AI systems. And there's also rules on deceptive design as well that may prevent generative AI systems from being used to manipulate or to draw users within interfaces in certain ways. So we could talk a long time about all the different pieces of legislation, but I wanted to highlight this double package, the DMA and the DSA, because there are the definitions in it are so wide, and generative AI systems are so wide in their functionality that it is unsurprising we see some overlap.
Fascinating. Yeah. And there's also the Data Act, Data Governance Act that you mentioned. Oh my God. I'm just have sympathy for European companies, and no wonder Emmanuel Macron make a complaint a few days ago, saying that, look, I mean, EU is staying, at the forefront of regulating, but not at the forefront of innovating. And if we pursue this part of the AI Act, then we won't have, leading AI firms in Europe. And by the way, he's saying that for advocacy of the French companies, because there is a French firm, kind of a moderate firm that recently raised $2 billion, receive a $2 billion US market capitalization. Yeah. So Macron wants to protect that. Clearly, whether his opposition, will make a difference, because based on our conversation yesterday, it looks like, they will go ahead because it's been finalized at the high level. They will go ahead with the AI anyway. But query, how strict the regulations would be. Let me bring out a hierarchy. Tell us about what's happening in Japan. What is the Japanese approach to governing generative AI? Because Japan is a very big player in this space as well. And then I actually learned from you that, Japanese people are actually, very friendly. They have very receptive to robotics and other AI systems. So keen to hear from you.
Thank you. So in terms of regulating generative AI, we did nothing. Do I still have time to make some additional supplementary comments? Yeah. It's not only about generative AI, but Japan is one of the most lenient, meaning less regulative countries on AI. There are several reasons. First of all, our society is aging, facing severe shortage of workers, leading many people to recognize that we need to use AIs. So so far we don't have a strong appetite to regulate AI. We have more appetite to use AI. That is one reason. And the second reason is since we haven't seen critical social risks on society caused by AI. So again, we don't have such a strong motivation to regulate AI. And third, we have a culture of, just mentioned by Angela, we have a culture of robot friendly. So we have a lot of comics animations where human beings and machines coexist and help each other. Of course, I know there are a lot of robots in Western culture who helps human beings, like R2D2, C3PO, or Lieutenant Data. But Japanese robot is more like emotional and more like a real friend, like human beings. So we don't have a so strong, strict differentiation between humans and robots because we are all part of nature. So for those reasons, we haven't moved swiftly for a regulation. And since the title of this conference is Regulating Generative Artificial Intelligence, I'd like to provoke the most fundamental question. Why do we need to regulate AI? Think about it. AI is a system that analyzes data statistically and outputs the most probable outcome of data or information. And this is exactly what was done by human beings in the long history. In business situations or public policy situations, then why do we have to create a new regulation on, especially for AI? So this must be the starting point of our discussion. I'm not saying that we don't need any regulation, but the starting point of question should be why, what's the difference between humans and AI? And if we talk about something already regulated, it's easier to answer. For example, if you use AI for driving a car or making a medical advice or legal advice, we may need a regulation because it is already regulated, meaning that it is regarded as high risk in the society. But still in this case, we may not need to create a new regulation as long as the AI is completely under control of human beings. For example, recently, Japanese Ministry of Justice announced that using AI for legal advices is basically legal as long as it is used by licensed lawyers. Likewise, humans could use generative AI as a tool to generate some regulated works, like making a report, as long as it complies with Privacy Protection Act or confidentiality duties. So this is one thing. But in some cases, even if humans supervise AI, if they still cannot fully control the risks, we may need to regulate AI itself. For example, in Japan, we have a regulation on medical devices using AI that even though the AI is used only by doctors, still their AI should be licensed because it has certain risks to the health of the patients. And further, if AI fully substitutes regulated activities such as full automated driving, of course, we are going to need a regulation for that AI. And how to design the regulation is another question, because it's ridiculous to ask AI to take the same exam as human beings take when you get the driver's license. So, but this is another discussion. On the other hand, Japan updates a lot of existing regulations to allow use of AI for regulatory purposes. For example, we amended recently the regulation on credit card companies so that credit card companies can use data and AI for credit scoring. So traditionally, they were asked to evaluate the credit score based on the given formula, which is very old-fashioned formula based on the salary and the composition of families, etc. And in 2017, we amended Copyright Act, which clearly says that using copyrighted contents for machine training purposes is completely legal. I mean, completely okay. It's not an infringement of copyright. Of course, there is some exceptions, like if the copyright holder clearly says no, then you cannot use the data for the machine training purposes. But in general, you can use that kind of copyrighted data only for machine training if it is not used by human beings. So, and on top of that, now we are revising more than 10,000 regulations and ordinances or notifications to enable AI to substitute for human beings. For example, we have a lot of regulations requiring human beings' existence to a certain premise for security reasons, or a lot of regulation that says human beings have to check by their eyes on the infrastructure security or like that. But now we know that AI can, or drones or cameras can do much better job than human beings. Now we are trying to renovate all these old-fashioned analog regulations. So these are the Japanese-based approach. And another question is, how about the activities that are not regulated for human beings? For example, hallucination. Telling a lie is not illegal, except if it's a fraud or if it's a false advertisement. Of course, it's illegal. But just telling a lie is not illegal. So why we need a regulation for AI to make sure that this AI will not tell a lie above a certain percentage? So this kind of and the answer to that question is that nobody knows the risks. So that's why we have to carefully monitor the risks caused by the AI or generative AI. And that's why I understand, the States or EU or UK or maybe China too, all have some research center or offices to monitor the risks of AI. But to Japan, we also monitor the risks of AI, but so far we have not detected any critical risks or catastrophic risks that could be caused to the society. So this is Japanese position. Thank you.
That's fascinating. So it looks like Japan is not like restraining AI, but actually is regulate to promote AI, is enabling AI. Yeah, in some way, it's very similar to, in a way, similar to what Chinese are doing.
Yeah, I think so. Yeah, but unfortunately, Japan is not the AA leading country. So I recommend Chinese companies or US, UK, European companies to come to Japan market. You can do anything.
We will take that offer. Now we have Microsoft representative here, and then we have other startups here. Let me go to Thomas. In addition to EU, US, and Japan, what do you observe other jurisdictions are doing in regulating generative AI?
Yeah, thanks a lot. So that's of course a big question, because the globe is a big place for regulation, and it depends a bit on how we think about jurisdiction. So if you think of jurisdiction as the ability to speak the law and maybe to enforce the law on a certain subject matter, and if you then ask who has jurisdiction, who speaks the law on AI in general or generative AI in particular, it becomes clear that there's a whole range of actors that play a role here. And that brings us into that debate of how to think about AI regulation, and whether that's the right way of framing the conversation, as Hiroki just suggested. Maybe it's a mistake to draft AI regulation and have conferences on AI. Maybe it's a different way of conceptualizing the transformations of economies and societies and the values that are at stake to then have more targeted interventions. And that debate is often framed in terms of horizontal versus sectoral. So should there be a law that applies to all AI generally across the board, stipulating obligations that providers of the infrastructures that enable AI will need to comply with? Or should there be regulation that is targeted towards the AI that's included in medical devices, or the AI that enables self-driving vehicles, or the AI that is being used to generate text in different contexts? And my sense is that we probably need both. So it's really not an either or question, but the regulatory debate tends to operate along those two lines. So horizontal versus sectoral, and the other 2x2 matrix is existing versus emergent and new regulation. So there's already a lot of law on the books, and the GDPR, as I said yesterday, can be understood as a kind of AI regulation. And Michael just told us how the platform regulation that the EU has created in the last couple of years, even though it was not meant to be AI regulation, is also AI regulation, can be repurposed in that way. Now, if you look around the world, there's some jurisdictions that try to do what the EU has just done with the AI Act. And in the discourse, Canada and Brazil seem to be among the most prominent. But of course, all these jurisdictions are subject to their own political economies, to the whims of elections and regulatory and political trends. And they all face this challenge that if you want to have horizontal AI regulation, if you make that political choice, very soon you need to come up with a way of defining what you are regulating. And in that regard, I think the AI Act delivers a cautionary tale. If you look at the European Commission proposal from April of 2021, the definition of what is an AI system comes straight out of a computer science textbook. So there's a list of methods you can use to create AI, and that includes everything from statistical data science-based systems to machine learning, from expert systems to rule-based systems. And all of these systems are AI. But that doesn't mean that we should regulate them in the same way. So the conceptualization that exists within one discipline is not necessarily the right one for another discipline. And that's increasingly understood, I think, in global AI regulation. And that means then that we shift away from the focus on how to define AI towards what kind of risk are we trying to regulate and what kind of infrastructures are at play in different sectors. And to conclude on that, so we see these attempts at horizontal AI regulation, but there's a lot of sectoral regulation that will impact different kinds of AI. So it's not the case that, and Michael alluded to that as well, that if AI creates certain risks within financial markets, that financial markets regulators will say, oh, this is AI, we won't say anything about it. No, quite to the contrary, they will take that risk very seriously and will try to address it. And that's also true for other kinds of regulators. So I said in the beginning, it depends on how you think about jurisdiction. And we tend to focus a lot on this panel and in general on the big public law type jurisdictions, states and supranational entities that create AI law and generative AI law. But there's a lot of private regulation, not just through standard setting or through private governance for, but simply through the negotiations that happen if you buy a certain kind of AI product and integrate it into your services. There will be a contractual negotiation that assigns liabilities, rights, and obligations between the two parties. And that's a kind of AI regulation as well. And universities, picking up John's point, are also a place where generative AI regulation is taking place because a lot of universities are concerned about the students using ChatGPT to write essays and take home exams. So they become regulators of generative AI as well. And I think it's important to zoom out and to take seriously all these other ways in which global AI regulation is taking place.
Fascinating. We are slightly running out of time, but I want to pose one last question before I open up the floor for Q&A, and I want to ask Hiroki about that. We talk about these various major jurisdictions, and it appears that there's different regulatory framework for governing AI. And can you identify like the major differences among these different approach. And for a large company like OpenAI, Microsoft or Anthropic, how could they possibly navigate this very complex regulatory landscape? Yes, please. This is the only and single slides that will be shown in this whole conference.
It's a shame we have this great screen and nobody used the screen. This one, yes. So let me just clarify the big picture of our AI governance framework. So actually, so this slide starts from fundamental goals of governance, but I wanted to write about risks, but because of the limitation of the space, I couldn't talk about much about risks. But so as I said, we have to start from thinking about risks. And then just as brilliantly explained by Professor in the keynote stage, which we have to think about what are the fundamental goals of governance that are like human rights, democracy, rule of law, economic development, sustainability. And now I really want to add love and mercy to this slide. Anyways, these are the common principles. And I think this level, most of the nations share these basic principles. And then we have, so about those fundamental goals, it's not relevant to AI. I mean, if you use or don't use AI, those fundamental values are essential. And then we have some AI principles, which is especially important in the context of AI, which is like safety, security, privacy, fairness, transparency, accountability based on validity. And Natalie several times explained that this is already shared by a lot of nations. At least people here all will agree on the basic framework. And then the real question is how to implement these principles or fundamental values into practice. And now you have the third layer of governance of AI systems, meaning that what activities or what conducts should be done by each player. Each player means a lot of stakeholders like AI data provider, AI developer, AI provider, AI user, etc. So there are a lot of players in the value chain, and what each player or AI actor should do is a practical question. And in a very high level, we all agree on certain principle on that, which is, you have to evaluate impacts or risks, and then you have to treat the risks, and you have to communicate with stakeholders about that. And also sometimes you need a third-party auditor certificate to give trust to that system. And you have to iterate that process because AI is always evolving. So this level, I think most of the guidelines frameworks are on the same stage, like US AI NIST AI risk management framework, or ISO TC42, or Japanese domestic soft law guidelines, etc. So we, of course, there are a lot of details, and if we start talking about the details, it's endless. But in the high level, we're almost on the same stage. And then the final question, the fourth layer, the bottom layer, is how to incentivize those players to do this costly process. So, and regulation is one of a lot of measures. So in addition to regulation, we have some standards, guidelines, I mean, soft laws to support the AI actors to do that kind of conduct. And also we can design property rights like IP rights or data access rights, etc. Or we have to design a good sanction model or liability model so that if you do a right thing, then you will be not be sanctioned or waived from some sanctions. And of course, we need some remedy systems in society. And this level is very, very hard to design because it's so contextual. Maybe in countries, you trust companies, so you want to ask companies to do first, and then in the at last you want to regulate. Or in some other countries, you don't trust companies that much, so you want to regulate from the beginning. And it's so contextual. There's no specific right answer, correct answer, and also the risk situation is always changing. So how to make it agile, multi-stakeholder and distributed processes under the cooperation of a global nation is really a difficult challenge. So my short answer is we are almost on the same stage until the third level. But in the bottom level, how to design a society is a real difficult question. And I don't think we have specific agreement on that.
Right, yeah, they would need to talk to you and consult with Hiroki about that. Okay, any questions from the audience? Yes, gentleman at the back, would you like to introduce yourself and?
Hi, around you. Thank you. I'm a director at a AI and legal tech startup. I had a question.
Are you interested in going to Japan now? After hearing?
I heard the it's very, very good there now.
You might want to move your microphone a little bit. Yeah,
Sorry.
okay.
I'm sorry about that.
No, oh,
Is that better?
put it down a little bit. Yeah, put it down.
Is that
Yeah,
better?
yes.
Sorry. Just a question for the panel. AI has been moving very quickly, and the fact that a harmful new innovation can appear that nobody has conceived of is a real possibility. And as you know, the legal and enforcement regimes often have a delay in terms of dealing with harmful innovations. Do you have any thoughts on how this could be addressed?
Look, I mean, you raise absolutely the key question here that, legislators and law enforcers, they usually don't jump into action until something really bad happens, right? I mean, we hear a lot of industry experts arguing, we need to regulate this because AI can pose potential existential risk. And earlier this year, there is like a group of leading thinkers in AI, the smartest people in AI was like advocating for halting, AI, suspending AI, for 6 months, but nobody listened to that, right? I mean, now there is a big race for, to develop AI. And my impression is after hearing, this panel today and from the observation yesterday is like, there appears to be, every country seems to be regulating, but underneath the table, they're not regulating. So it's mostly performative. You wrote an excellent piece on race to regulate AI. What's your take on this?
So I agree with what you just said. But I do think that there are ways, because in a way, it's also the question of, is regulation always running behind on innovation? And I usually try to push back a little bit against that narrative. And the example I often give is that in Belgium, there are still like principles and rules from the Roman law that we apply. So if you design your regulation in a smart way, it can still be applicable even when new innovations arise. But that requires specific regulatory techniques. And to be very honest, I don't think the AI Act fulfills that requirement, but that's another story.
On this?
Yeah, I agree with Natalie that it's not the case that regulation is necessarily lagging behind, but of course there are problems in terms of figuring out what's going on. And I think one positive effect that the AI Act might be able to have is to increase transparency into industry structures surrounding AI and to then figure out what kind of interventions to make. But the problem is that if, picking up on Hiroki's point, if we need regulation that is adaptable to different kinds of risks and to new industry configurations, to new developments, we need ways to assess what works and what doesn't. And we need to have ways of changing regulation when it doesn't work. And that has historically been a big problem with European regulation because it's so hard to change it. So if you wanted to have regulation that you can change, you need to build regulation that you can change. And if you want to have data that allows you to assess whether regulation worked or not, you need to build regulation that generates the data that you need to assess whether regulation worked or not. And those are two elements that future AI regulation arguably should think more about.
Right. I mean, I mentioned earlier that you see the US firms are making voluntary commitments to subject themselves to a variety of, rules and regulations. They commit themselves to do a lot of safety tests and stuff. One speculation was that they're doing this in order to increase entry barrier, but a lot of people think that they're really doing this for the benefits of humanity. And also because they want to raise the industry standard. Because if if there is a bad apple in the industry and if something really bad happened, then it will ruin people's trust in AI. So the biggest players like OpenAI, they have very strong incentive to raise the industry bar so that, people will continue to trust and have confidence in the product. And like OpenAI, I think it invested 20% of its computing power to ensure in a project called super alignment. And as we read in the newspaper in the last couple of weeks of the OpenAI firing Sam Altman, this huge drama. And a lot of people thought that it has something to do with AI safety, but yeah, go ahead, Michael. Yeah, please.
Because so a few things to me. One of them, you mentioned that open letter, for example. Open letters in that space, are very heavily used as a lobbying tactic. That one in particular was subtly funded and pushed by the Future of Life Institute, which has just got a normal PR strategy of constantly pushing open letters for its own financial gain and its own the focus on its own organization and its own ends. And so when we think about the law keep up with technology, law often keeps up with technology quite well. It doesn't keep up with business practices very well.
Okay.
And it doesn't keep up with business practices very well. And so when we also look at, say, OpenAI and their investments and their focus on alignment, a lot of this is also in the context of a company that initially was going to put technology out there for everybody to consume and now wants to constrain it down to a business model that it controls, and then it can be paid per query for every single time it engages in this. And we also don't have a very good insight into where any of that funding on these issues go. The push for alignment and AI safety happens to align very, very closely with the push and with a business model of closed systems and intermediation, where companies would be in the middle of every single computation in the world and be charging per query and would resist opportunities to open up a model or have other actors take control and to be able to use these powerful models on their own servers or on their own devices, and instead have to keep this company in the loop. So I think we have to be careful when we look at company initiatives and their propensity for regulation. OpenAI has only just started hiring almost any policy people whatsoever in countries, in country level. In the UK, in Europe, they've had a few people internationally who do sort of policy talk, but actual policy officers to engage with government, that's like a completely new thing in their organization, frankly.
And that's why you were pissed off when Helen Toner wrote the piece and saying Anthropic is doing better.
Well, I think that the people on that board also come from this AI safety landscape. And so I'm not sure that's really a kind of battle that we should be too focused on. The company itself is an intermediation company. What it wants to do is to sell its product and to put its product into a lot of other products. And we should always be wary whenever any narrative comes around social responsibility. How would their version of the narrative affect their business model in future? And I think that's a question we should pay attention to, and that's where regulation doesn't catch up very well. But as I pointed out, and as Thomas mentioned, we can repurpose things like platform regulation, because there's nothing new under the sun. We've been doing intermediation since the age of money lenders, in villages and towns. This is just another version of this that we may need more focus on to kind of get the confidence that this is nothing new, something actually eminently regulable.
Right. Very good. Any other thoughts? Yes, John Paul. You microphone, speak into the microphone and turn on the microphone.
Question goes to Natalie, maybe also for Thomas, because it's a question about the US. Natalie, I agree with you that it's unusual that Biden AIEO invokes the National Defense Act, the legal ground to manage IIM companies to submit data to the government. My question is, do you think does that mean that the US government views the large language model as having military implication rather than a civilian technology? Or is it really because they kind of lack proper legal tools to mandate the company to do that?
So you were saying that the US was targeting at the military use of the foundation model rather than commercial use, is that?
I mean, because it's not euro, for the US to invoke national defense.
Oh, yeah, okay.
Military implementation.
So I think there is definitely a lack of tools. And this was one tool in the toolbox available for the president in order to draft his executive order and have something that he could claim from these companies, because that's not something you can normally otherwise do via something that is not regulation. And I'm not sure, I think the whole language about security that you see in the executive order, I think it's not just a military fear, but more generally national security. It's national security, it's public health, public safety. So they're very broad words being used. But I think undoubtedly, these models could be used for so many different purposes, including purposes that would harm national security, including defense. But I think national security as such is already problematic enough. But again, it's part of the toolbox. And if you use those words, you can trigger those tools. So you need to be practical as well, I think.
I definitely agree with Natalie on that point, right? I mean, in fact, the Biden administration has already stretched too far in relying on this, what is it called, the Production Act? The Defense Production Act, because they've really run out of tools. So they rely on this Emergency Act, which they used during the Korean War to put in the executive order. And this is actually an act that allows the government to ask firms to produce necessary products during defense time. But they're using it to kind of force firms to make disclosure, right? I mean, so and so when the EO came out, there was a huge debate in the U.S. whether the government is pushing too far, and potentially this could subject them to litigations. And EO, have a lot of limitations, right? I mean, its implementation is far from perfect. In previous cases, the implementation is about 60 to 70%, right? So, and the EO can only bind the U.S. federal government, right? I mean, you're seeing the Biden administration is doing a whole of government approach to enable AI. So, yeah, we can't read the EO too seriously. And by the way, I mean, Biden might be out in a year, right? When the next president come out, I mean, the EO will be forgotten. Yeah, Thomas.
Yeah, maybe just to add one point in how to think about AI regulation and what's happening in the United States. So if you try to regulate AI, we can try to regulate a certain product, like a medical device that includes AI capability. We can try to regulate a certain service that is being provided using AI. And I think we focused a lot on those kinds of AI regulation. But another approach would focus on the components that you need to develop an AI system. So less the application stage, more the development stage. And that's the other area where the Biden administration has been focused on, because AI systems, as computational systems, require hardware, software, and data. And if you look at those categories, it becomes quite clear that it's relatively difficult to regulate data in the US in particular, because of the historical Silicon Valley consensus that there's a lot of data out there, and once it's out there, it's difficult to regulate. It's also surprisingly difficult to regulate software. So we gestures towards the phenomenon of open source software and open source AI models. So once the model is out there, how do you regulate it if it's widely available? But what you can regulate, and what the Biden administration tries to constrain, in particular with regard to trade to China, is hardware, in particular chips that are specialized for complex graphical computations, including now increasingly specialized AI chips. And there's, of course, a national security rationale behind it, but I think there's also a regulatory insight here that it's easier to regulate hardware than it is to regulate software or data.
Did you also ask him about EU, Thomas? No, okay. Yes, would you like to introduce yourself?
Hello, my name is David Uriel, soy de la Osa Motelevich Casado. It's a little long, I know. Thank you for the fantastic panelists for such.
Japan?
Thank you for, yes, absolutely. I'll do the introduction. But first I want to thank the panelists for such insightful commentary. So my background is first in diplomacy for the Ministry of Foreign Affairs of Spain, and then I worked as a practicing lawyer internationally, but mainly based out of the United States in the financial sectors and then in technology transactions. So the question that I want to pose to the panel.
Flew from Japan.
I flew directly from Japan just for this conference because that's the level of panelists that you brought. So special thanks to Angela for that and for all the fantastic people that have made this conference possible. So one of the thing that I wanted to bring to the table, and I think perhaps Natalie and Thomas are particularly equipped to respond to this one, is something that I haven't really heard about spoken in this panel. We've talked a lot about regulation, but we haven't talked about institutional development. So for example, China has generated this entirely new algorithmic registry through one of the regulations, through one of the most recent regulations on algorithms. And I was wondering if you could provide some insight as to the projection about the current status of institutional development and about the projections in general through OECD countries, in Europe and in the United States. Thank you very much.
You will complement whatever I I skip. So I will speak about the AI Act specifically and what institutional capacity will come with that. So there will actually be a sort of similar registry. It's not an algorithmic transparency registry, which we do see in some European countries and some European cities. For instance, Amsterdam and Helsinki have done that. But at the level of the EU, there will be a database in which high-risk system providers need to register some basic information on their system. It's very basic information, so it's not a good transparency tool when it comes to like the capabilities of the system, but at least it tells you which kind of high-risk systems are on the market. Additionally, and this is something that the Council proposed, and in principle, it will be in the final version, public sector users of high-risk AI systems will also need to register themselves. So it's high-risk providers and public risk users. In addition to that, there is, of course, enforcement capacity that is introduced, which is very important. And that is also to make sure that it doesn't remain teatless. So yes, there is no ex-ante licensing, but ex post, there will be an extensive monitoring system. So at the national level, each EU member state has to designate a national supervisor of the regulation. And then at European level, you will have a European board that will coordinate and exchange best practices amongst the national supervisors, plus an AI office. And this AI office, a little bit similar to what we also saw in the DSA, where it's the European Commission that said, you know, we ourselves will need to tackle the very large platforms because member states are not capable of doing that themselves. So this AI office will deal with the largest AI system providers, such as foundation model providers, to enforce that. So this is in a nutshell.
You want to stand? Yeah, please, Michael.
And on this, there's also a couple of areas which I think are less appreciated in the AI Act, and it's hard to say because we haven't got the final text or the final version. But placing on the market an AI system and therefore putting it in this database includes, in the earlier versions at least, if you were going to build that system for your own internal use. And that is interesting because it would say that if Amazon built a hiring system for Amazon workers itself, then it would have to be placed inside this database. And that is a very significant transparency area for this combination of provider and user. But I think one of the challenges around this is that the AI Act is fundamentally flawed insofar as it puts enforcement on the market surveillance authorities in member states. And market surveillance authorities are not well equipped to undertake almost any of these tasks. They are very much a post-market surveillance tool where they say, we just check if anything is going terribly wrong. They are not an investigatory force, and they certainly are not a force which can deal with the regulation being extended to the users of AI, which is what has happened in the AI Act. So there's an assumption that was made that you could just add the word, oh, and we'll bring use into the scope of a very old type of instrument. The AI Act is a very old instrument. It's based on a type of EU law that's been around since the 70s onwards, called the New Legislative Framework. But these authorities have never regulated use and users. The closest they ever get to regulating a user is actually the lifts directive, where the sort of the process of buying a lift includes the process of installing it, but it doesn't include the process of actually operating it. Nowadays, we're going to get to a point where we just have a lack of a regulator then that can deal with any of these user areas. And so I find at that point, it's going to be very confusing as to who is actually responsible for not just the providers, but the user obligations in the Act Amendment.
No, I think I agree with Michael and Natalie on that. Just in response to David, I think there's an interesting way of understanding your question about institutional developments, and we focused a lot on the need to develop institutions that are able to understand AI as technology, as an infrastructure, as an industry, and to have the kind of regulatory capacity that the European Market Surveillance Authorities do not have. But the other institutional development question is the one that John raised earlier, which is what kind of AI do institutions need to implement to fulfill these kinds of tasks? And that's, of course, a question that governments ask themselves, that international or intergovernmental organizations ask themselves, and that businesses and universities all ask themselves. Well, how do our organizational structures, our social practices need to adjust in a world in which new AI systems are available that change the way in which information is generated, change the ways in which communication occurs, and change the way in which regulation that is effective and fulfills the objectives that we have towards a prosperous, happy AI society is actually being fulfilled?
This is an excellent question, by the way. I mean, I would say the EU is, if there is any jurisdiction that have the capacity to regulate AI, I would think EU will probably be, the best suited to do that, because there's no other country, organization in the world where you observe a very dedicated institution that is independent from the government, right? I mean, EU is a transnational organization. Where people there were all policy entrepreneurs. You were one part of them. And he was thinking about nothing but regulation. So they're really, really fixated on regulating. And that's why, you see EU has turned out, numerous regulation in the past few years. And EU really want to stand at the forefront of regulating AI. They're very determined to do that. But that might also hampers the overall objective about AI development, because if you only have this tunnel vision of regulating, but you don't bear the cost of regulation, because it would be ultimately the national government that pay for the bill, but EU doesn't pay for that, that might eventually backfire in that they might over-regulate. But let's watch this space. So this concludes the first panel for this morning session, and then we will come back at 11:15. Okay, see you in a bit.